Hello everyone. In this video, we will understand the concept of gift under transfer of property law. In legal terms, a gift refers to the transfer of ownership of property without any consideration, meaning without any payment or without any compensation or any return benefit. Because of this, a gift is not a commercial transaction. Gift is a voluntary and gratuitous act based purely on free will of the person transferring of the property. The core feature of a gift is the absence of consideration. Even if a small piece of exchange is involved, the transaction cannot legally qualify as a gift. Once a valid gift is completed, the entire ownership immediately passes to the donee. From that moment onwards, the donor loses all the rights, control, and interest in the property. This is why a gift is fundamentally different from a sale. In a sale, ownership transfers because of payment. In a gift, ownership transfers solely because of intention and generosity. For instance, when a father transfers his house to his daughter out of love and affection without receiving any money, the law treats this transfer as a gift and not a sale. This legal meaning and framework of gift is clearly laid down under Section 122 of Transfer of Property Act 1882. Now, it is important to understand that not every transfer without money automatically becomes a valid gift. Property law is very clear that a gift is a legal transaction and therefore certain essential conditions must be strictly satisfied. First, there must be a transfer of ownership of the property. Merely handing over possession or allowing someone to use the property is not enough. Unless ownership itself is transferred, the transaction cannot be treated as a gift. Second, the transfer must be voluntary in nature. A gift must come from the free will of the donor. If the transfer is made due to force, undue influence, coercion, or fraud, the law will not recognize it as a valid gift. Thirdly, there must be complete absence of consideration. This is a crucial requirement. Even a small amount of money or any form of benefit is given in return will destroy the concept of a gift. Further, a gift always involves two parties, that is, the donor who gives the property and the donee who receives the property. Both parties must be legally competent, meaning they should be capable of entering into a valid legal transaction. Therefore, a gift is not merely an emotional or moral act. It is a formal legal transfer governed by clear statutory conditions. For example, if a person transfers property after receiving money and still describes it as a gift, the law will ignore the label and treat the transaction as a sale and not a gift. Now, this is one of the most critical aspects of a gift, and it is also the point that students mostly common overlook. Acceptance of gift is mandatory. Under the Transfer of Property Act, a gift is never complete merely by executing a gift deed. No matter how clearly the donor expresses intention, without acceptance by the donee, the gift has no legal existence. Meaning, the donee must agree to receive the property. Gift is a bilateral transaction. It requires giving as well as receiving. Another very important rule is that the acceptance must take place during the lifetime of the donor. If the donor dies before the donee accepts the gift, right, the transaction automatically fails and no rights pass to the donee. Acceptance does not have to be formal are written in every case. It may be expressed such as a clear statement of acceptance or implied inferred from the conduct of the donee. For instance, when the donee takes possession of the gifted property or it starts using it, occupying it, or exercising ownership rights, the law presumes that acceptance has taken place. To give a simple example, if a house is gifted and the donee starts living in that house, then there is no need for a separate acceptance document. Acceptance is complete by conduct. So the rule is very clear and must be remembered without confusion here. No acceptance means no gift, no matter how genuine the intention of the donor may be. Now let's look at mode of making a gift. Section 123 covers it. Let us now examine how a gift is legally created under property law. The law does not allow gifts to be made casually. Instead, it prescribes a specific mode which depends on the nature of the property involved. When the gift relates to immovable property, the law is very strict. Such a gift must be made through a registered instrument, commonly known as a gift deed. Registration in this case is mandatory and not an optional. In addition to registration, the document must also be attested by at least two witnesses. Without fulfilling these formal requirements, the gift has no legal validity, even if both parties genuinely intended to transfer. However, the law adopts a more flexible approach in a case of movable property. A gift of movable property may be made either by actual delivery of the property or through a registered instrument if the parties choose that method. This distinction shows that the law treats movable and immovable property differently. Registration is compulsory only for gift of immovable property, whereas delivery is alone is sufficient for movable property. To understand this clearly, consider the below example. If land or a house is gifted without executing and registering a gift deed, the transaction is invalid in law even if the donor and donee both agree and act upon it. Next one is revocation of gift. This is covers under the section 126 of Transfer of Property Act. As a general rule, the law treats a gift as a final and irrevocable transaction. Once a valid gift is made and accepted, the donor cannot take it back at his own will. This is because after completion of the gift, ownership completely passes to the donee and the donor loses all the control, interest, and authority over the property. Therefore, a gift is normally permanent in nature, unlike some other transactions where rights may be continued. However, the law does recognize that in exceptional circumstances a gift may be revoked. Such revocation is strictly limited and cannot be exercised arbitrarily. Firstly, a gift may be revoked by mutual agreement between the donor and the donee, provided such a condition for revocation was expressly agreed upon at the time of making the gift and is not dependent solely on the will of the donor. Secondly, a gift may be revoked on grounds similar to those applicable contracts, such as fraud, misrepresentation, coercion, or undue influence. In such cases, the gift is treated as legally defective from the beginning. Here, what is very important to remember is that unilateral revocation is not permitted. The donor alone cannot cancel or revoke the gift date merely because of a change of mind. For example, if a donor later regrets gifting his property or feels emotionally dissatisfied with the donee, such regrets does not give him any legal right to revoke the gift. Now let's look at actionable claim. Let us move to the concept of actionable claim, which is very different from a gift or transfer of tangible property. An actionable claim does not involve ownership of property itself. Instead, it refers to a legal right to cover money or to claim beneficial interest that can be enforced through legal action. In simple terms, an actionable claim is a right to sue, not a right to possess property. The law specifically includes unsecured debts within the meaning of actionable claims. This means if money is owed to a person without any security, such as mortgage or change or charge on property, the right to recover the money is an actionable claim. If the debt is secured by mortgage, pledge, or hypothecation, then it does not qualify as an actionable claim. Although an actionable claim relates to the money, the law treats it as a movable property, not as immovable property. This legal classification important because it determines how such rights can be transferred. To understand this better, consider an example. Money payable under an insurance policy or money due under an unsecured loan does not give ownership over any property, but gives a right to claim payment and therefore constitutes an actionable claim. The legal meaning and scope of actionable claim is defined under the Section 3 of Transfer of Property Act 1882. Now we understand the actionable claim is what all about. The next question is whether such a right can be transferred. And the answer is yes. The law expressly permits the transfer of actionable claims. The transfer must be made by a written instrument or this instrument must be signed by the transferor. No oral transfer is recognized. Now let's look at examples for actionable claim. These examples plays a crucial role in understanding the true scope of an actionable claim. In general, any right that allows a person to recover money through legal action without having a direct interest in property falls with this concept. To begin with, money due under an unsecured loan is a classical example of an actionable claim. Here, the creditor has no security over the property, only a right to recover the amount. Similarly, the amount payable under an insurance policy is an actionable claim. The insured does not own any specific property of the insurer, but only has a legal right to claim money. Another example is arrear of rent, provided such rent is not secured by a mortgage. If the rent is secured, it moves out of the category of an actionable claims. Now let's look at what is gift versus sale. Students often confuse gift with sale, but the distinction between the two is very clear in law. The most fundamental difference lies in consideration. A gift is made without any consideration, whereas a sale is made for a price paid or promised. A gift is voluntary and gratuitous in nature, while a sale is contractual transaction governed by mutual obligations. In the case of a gift, acceptance by the donee is compulsory. Without acceptance, gift is incomplete. In contrast, acceptance is not a separate legal requirement in sale, as consent is already built into the contract itself. Therefore, the moment money or monetary value enters the transaction, the law treats it as a sale, irrespective of how the parties describe it. To conclude, a gift is a transfer of ownership made without consideration, and acceptance by the donee is essential for its validity. An actionable claim, on the other hand, represents a right to recover money and is legally treated as movable property, even though it does not involve possession of goods. Both concepts are short in syllabus but extremely important for examinations. A clear understanding of these principles helps avoid confusion and builds a strong foundation in property law under the Transfer of Property Act 1882. If you found this video helpful, please like, share, and subscribe. Thank you for watching.